just old business, nothing else after that?
Yes, sir, yeah.
All right, perfect. This was with all the new evidence that we obtained, right?
Yeah.
Okay.
I know we use this, just our thing. We should be able to read this.
Just wait for Mr.
You can let us take the elevator down.
Yes.
How you doing? Good. I'm not in your seat, am I?
Right here.
Let's go ahead and start the meeting. I don't know if you all have heard, but Mr. Kane has resigned from the board.
Okay.
Mrs. Deborah has also resigned, but we haven't officially gotten a resignation email or letter from her. So technically, she's still on the board until that happens. Before tonight's meeting, we will have to appoint a temp, a chair pro temp, temporary, if I'm pronouncing it correctly. So we could potentially do that and then just jump right in if you all want to do that.
Yeah, okay.
So you all can go ahead and I guess make the vote, then we'll start. Or do you want to nominate Mr. Forbes, since he's been in that role a few times?
Yes.
Everybody's
I have a motion. I'll nominate Mr. Forbes to be president pro tempore for this meeting.
I'll second.
I guess we just vote.
Yeah, you can vote.
Aye.
Aye.
So,
And that is something I guess we're going to have to do, appoint a new chair and vice chair in the near future. So we'll discuss that probably for the next meeting.
And when do the election terms reset?
That I have to find out for sure. So I'll get with the liaison for the boards and confirm that with her. I thought it was in October, but I'm not 100% sure.
I think it's this month or next month.
Okay. Okay. I'll confirm that. So we'll kind of just jump in. I'll call the meeting to order at 5:33 p.m. And then we will have the adoption of the agenda.
Mr. Chair,
Yes.
I move to adopt the agenda.
Is there a second?
I'll second.
All in favor, say aye.
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 All opposed? All right. I think we approved this agenda.
And then we'll have the approval of the minutes from April 18th, 2023.
I have a correction for the minutes.
Okay.
It says approval of the minutes for the February meeting the motion was seconded by me, but I wasn't at the February meeting, so I did not second the motion. Because I never, yeah. I wouldn't have
I think that's a
known.
typo. It should have
Yeah.
been April, okay?
Okay.
So we'll correct that. It's in the meeting, the minutes.
Under approval of the
Yeah.
minutes.
Okay. question.
Wait, give me 1 second, because I remember thinking something. So approved as recommended, that's when we accepted the office's recommendation. And then back here where it just says approved, is this meaning we asked for more information?
Yeah,
Okay,
the motion that was set forth was approved.
got it.
Yes. Okay. Will I have a motion?
Yep.
I move to approve the April 18th, 2023 minutes. Great. Well,
Yep. Is there a second?
With the correction, second.
With the correction, seconded. All in favor?
aye.
All opposed? Okay, we approve the minutes of the April 18th meeting with Ms. Palacio's correction.
And then we have old business, Keenan Roads, that's EO-E-2022-32. And the Human Rights Board can discuss and take action as deemed appropriate.
Will there be a reading of the new discovery or no?
Excuse me,
Will there be a reading of the new discovery or no? The
Uh,
supplement?
if you all would like, whatever you all would like to do. Does anyone want me to read the new additional supplement in the record? Have you all reviewed it?
I've read it. Yeah.
So you should have a script in your packet, and I'll be the acting equal opportunity director for tonight. And this is case name Keenan Rhodes v. McKibben Hotel Management, Inc. The case number is EO-E-2022-32. The Equity and Inclusion Office has provided the members of the Gainesville Human Rights Board with a written report concerning complaint of discrimination EO-E-2022-32. We have processed the complaint as required by Chapter 8 of the city's code. We are here today to report our findings as to whether reasonable cause exists to believe that an unlawful discriminatory practice has occurred in accordance with the City of Gainesville Code of Ordinance 8-48 F. We are now ready to report the results of our findings concerning complaint of discrimination EO-E-2022-32. Members of the board, thank you for your presence and participation. You have each received a copy of the supplemental investigative report for complaint EO-E-2022-32 and have had time to review the findings. I will now summarize the findings as it relates to this case. The complainant alleged that the respondent retaliated against him after the complainant reported the respondent's discriminatory actions to the respondent's complainant service department. The complainant alleged that the respondent unlawfully terminated the complainant after the complainant reserved a hotel room at one of the respondent's sister properties. Respondent's position. The respondent denied discriminating and retaliating against the complainant. The respondent alleged that the complainant was terminated because he was insubordinate, belligerent, and disrespectful towards his supervisor, thus violating the respondent's code of conduct. Summary of investigative findings. On April 18th, 2023, the City of Gainesville Human Rights Board, the board, remanded this case for additional investigation. Specifically, the board requested that the Office of Equity and Inclusion provide the board with a copy of the Hilton Code of Conduct in regards to the respondent's Go Hilton travel program. Additionally, the board requested that the assigned investigator confer with the respondent's general manager, Mr. Husan Paris, to obtain answers to the following questions. 1, whether Mr. Hussein Paris was aware of the June 11th, 2022 online discrimination complaint that the complainant submitted to the Hilton Guest Correspondence email in regards to his stay and experiences at the Hampton Inn on June 10th, 2022. If Mr. Paris became aware of the complainant's June 11, 2022 online complaint, when did he become aware of the complaint? 2, whether or not the agreement that Mr. Paris and the complainant made about it not being in the complainant's best interest to go back to the Hampton Inn was memorialized in a document or writing. On April 24, 2023, Interim Compliance Manager Mr. Dualei spoke with General Manager Mr. Hussein Paris. Mr. Paris informed Mr. Dualei that the General Manager from Hampton Inn forwarded Mr. Paris the complainant's discrimination complaint email from June 11, 2022. Mr. Paris received the forwarded email from the General Manager from Hampton Inn on June 14, 2022. Mr. Paris provided Mr. Dualei with a copy of the forwarded email from June 14, 2022. Mr. Paris also informed Mr. Dualei that on June 14, 2022, Mr. Paris and the complainant had a discussion regarding the complainant's future stays at Hampton Inn. During this discussion, Mr. Paris and the complainant agreed that it was not in the complainant's best interest to go back to the Hampton Inn. Mr. Paris stated that this conversation was not memorialized in a writing. However, Mr. Paris indicated that the Assistant General Manager, Clayton Stark, was present for this conversation. The evidence provided did not change the Office of Equity and Inclusion's initial recommendation. There is no reasonable cause to believe that the respondents violated Code of Ordinance of Gainesville, Florida, Section 8-48, parentheses F. As indicated in our written report, we have determined that there is not sufficient information that will lead an impartial observer to believe that a discriminatory practice occurred. If you do not believe that there is reasonable cause to believe that a discriminatory practice has occurred, the Equal Opportunity Director must dismiss the complaint. You also have the discretion by a 3/5 majority vote to order such further investigation as deemed necessary. Your decision should be based on the evidence of record. Chair, as required, we have provided the board with evidence concerning our investigation of complaint of discrimination EO-E-2022-32. You must now make a determination based on that investigation.
Members of the board, you've had the opportunity to read the investigative report concerning complaint of discrimination EO-E-2022-32 and heard the summary of that report provided by the compliance investigator. What questions, if any, do you have concerning the report, keeping in mind that any questions from board members should be directed to the chair pro tem?
No further questions.
No. None.
Christina, did you have any?
I was just, I guess I did one small question and said, Mr. Paris at the end of the supplemental script indicated that the Assistant General Manager, Clayton Stark, was present. Just refreshing my memory, he actually confirmed the conversation.
Mr. Clayton confirmed the conversation. However, he did indicate that he couldn't hear the
The
words
other side.
that were spoken on
Right.
the phone by Mr. Rose.
Okay. But it was consistent with what he heard, it was consistent with the responses that were given.
Yes.
Okay.
Yes.
Parties of interest, that is complainant and or the respondent, you have the opportunity to take the floor and speak if you'd wish. The time limit of debate is going to be limited for all parties to 3 minutes each. Is there anyone from the complainant's party who would like to speak?
Mr. Rhodes, are you?
I just requested he muted, he's still muted.
Okay, give me 1 second. Let's see if I can get a number from my office. You got the meeting?
Okay.
Mr. Rhodes, would you like to say something?
Are we muted?
No.
Let's try that. Try
Oh.
to ask him again.
Mr. Rhodes, can you, would you like to say something, Mr. Rhodes?
No, I'm fine.
All right, thank you. And I don't think there's anyone from the respondents party
No.
here. Okay.
Were we already in a meeting?
We're currently meeting about your case, yes?
Yeah, I didn't like, y'all have been in a meeting since 5:30?
Were we muted the entire time?
I believe so.
Yeah, I didn't hear anything at all.
Yeah, there you go.
So what do we do?
I can read.
I was on the phone with the office saying that no one's at the meeting, and I heard nothing at all. I've been sitting here waiting.
Give us 1 second, that's our bad. I think we were muted on our end.
Yeah,
Okay.
I can read the summary of the investigative findings again.
Okay.
I thought you had the meeting, I'm sorry.
Oh.
That's
All right. So, summary of investigative findings in Mr. Rhodes' case, EO-E-2022-32. On April 18th, 2023, the City of Gainesville Human Rights Board remanded this case for additional investigation. Specifically, the board requested that the Office of Equity and Inclusion provide the board with a copy of the Hilton Code of Conduct in regards to the respondent's Go Hilton travel program. Additionally, the board requested that the assigned investigator confer with the respondent's general manager, Mr. Husan Paris, to obtain answers to the following questions. 1, whether Mr. Husan Paris was aware of the June 11, 2022 online discrimination complaint that the complainant submitted to the Hilton guest correspondence email in regards to his stay and experiences at the Hampton Inn on June 10, 2022. If Mr. Paris became aware of the complainant's June 11, 2022 online complaint, when did he become aware of the complaint? 2, whether or not the agreement that Mr. Paris and the complainant made about it not being in the complainant's best interest to go to the Hampton Inn was memorialized in a document or writing. On April 24th, 2023, Interim Compliance Manager Mr. Dualei spoke with General Manager Mr. Husan Paris. Mr. Paris informed Mr. Dualei that the General Manager from Hampton Inn forwarded Mr. Paris the complainant's discrimination complaint email from June 11, 2022. Mr. Paris received the forwarded email from the General Manager from Hampton Inn on June 14, 2022. Mr. Paris provided Mr. Dualei with a copy of the forwarded email from June 14, 2022. Mr. Paris also informed Mr. Dualei that on June 14, 2022, Mr. Paris and the complainant had a discussion regarding the complainant's future stays at Hampton Inn. During this discussion, Mr. Paris and the complainant agreed that it was not in the complainant's best interest to go back to the Hampton Inn. Mr. Paris stated that this conversation was not memorialized in a writing. However, Mr. Paris indicated that the Assistant General Manager, Clayton Stark, was present for this conversation. The evidence provided did not change the Office of Equity and Inclusion's initial recommendation. There is no reasonable cause to believe that the respondents violated Code of Ordinance of Gainesville, Florida, Section 8-48, parentheses F.
And so, when we were during our questioning period, Ms. Palacio asked a question about whether or not, what was in Clayton Stark's involvement in the conversation. And Mr. Dualehi confirmed that Clayton Stark said he was present for the conversation, that he only could hear one side of the conversation because he wasn't on the phone with the complainant. And I think that was the only question that the board had. And this is the point at which we offered you a chance to speak, Mr. Rhodes, and we realized that you couldn't hear us. So you have 3 minutes to speak if you would like to say something for yourself.
Yes, I did hear that. I honestly want to know what Mr. Clayton Stark being in the room had to do with anything, or if anyone even, like, does that count? Like, for him to say that, oh, like, me and him did have an agreement, does Mr. Clayton Stark, does his word count? Like, is it firm? Like, I want to know that, because I know my side of the story and how everything went down. The only time that I knew Clayton was on the phone is the the phone call where I got terminated. He said, hey, Mr. Rhodes, I have Mr. Clayton here with me. We've decided to terminate you. That's the only time he was on the phone. Now, the phone call that we've had prior to that, there was no mention of Mr. Clayton being there or me knowing that he was there. So, like, I'm not really, I thought this was going to be like just a hearing for a decision or something, so I didn't prepare anything, so I'm not really prepared to actually speak.
Thank you.
So to answer that question, Mr. Stark was listed as a witness in this case. So his word, I would say, does add value to the case, because it was, from my understanding, really only a total of 3 witnesses: the complainant, Mr. Parrish, and then Mr. Stark. And Mr. Stark confirmed that he overheard Mr. Parrish's portion of the conversation, where he indicated that it wasn't in the complainant's best interest to go back to Hampton Inn. So he just corroborated what Mr. Parrish attested to when he was spoken to during this investigation.
But him just saying that on the phone, and Clayton Stark hearing him, like, I'm not understanding how that is the deal breaker, or the strongest point here, that he was in the room hearing something. I'm still trying to figure out why I got fired because I filed a complaint.
Well, I would just answer your question by the conversation that was had between whether or not it was in your best interest to go back to the Hampton Inn, is specifically referring to one of the questions that the board wanted our office to obtain, whether or not this particular conversation was in a writing or not, or whether it was just all verbal. So I wouldn't say that one point kind of is sufficient enough for your case. That one point is going to a specific question that we were asked to answer.
Okay, gotcha, understood. I'm sorry, I had a misunderstanding.
Thank you. Okay, board, I think we're ready to vote. We may only consider the evidence of record in the question of whether or not this was a retaliatory firing, termination. The Equal Opportunity Director has determined that there is not sufficient information that would lead an impartial observer to believe that a discriminatory practice has occurred. You should vote A if you agree that there is no reasonable cause to believe that a discriminatory practice has occurred, and you should vote nay if you believe that further investigation is deemed necessary, in which case we'll specify the areas of further investigation.
I have a motion.
Yes.
I move to approve the determination by the Equal Opportunity Director and Complaint of Discrimination EO-E-2022-32.
Is there a second to approve the recommendation?
I second.
All in favor?
Aye.
Aye.
All opposed? All right, I believe we have an approved motion. We are, as a board, choosing to accept the office's recommendation.
And what was the office's recommendation?
The board has voted that there is no reasonable cause to believe that a discriminatory practice has occurred.
Is it discrimination or retaliation? I'm not like trying to be a smart aleck or anything. I just thought I filed for retaliation. Is that like not different?
It's a retaliation complaint. However, it's kind of, I guess, housed under the umbrella of discrimination, if that makes sense.
Oh, excuse me?
So retaliation would be like under the umbrella of discrimination. So your complaint is a retaliation complaint, but it's under the umbrella of it being a discriminatory act.
Yeah, but he literally called me after all that happened and told me I was fired because of that. So me and him had no like further issues at the workplace. Like for any of that to happen, that happened only because of that, and that's the only reason I pushed for that. Because Mr. Hussein Paris really didn't have anything to do with it. Like I found out that like those were two separate companies, so I don't even know why like they were contacted for me to get fired. You know what I'm saying? That was supposed to be a separate issue, and that's why I was feeling like it had to be retaliation because they talked about it on a personal level amongst themselves without me there, and then that's when I got a call.
Yep, so you filed for retaliation, but retaliation as a form of discrimination. And after seeing the initial and the supplementary investigative reports, the board has determined that there was no cause for a discriminatory practice has occurred.
Understood. I'm sorry, just one more question. But that was because I remember last time we was in the meeting, you guys said I thought it was more than one question. If that was just the one question was about Clayton Stark, or I can't even remember his name, about Mr. Clayton, was that the only question that was wanting to be asked?
No, that was one question. I think, for me personally, the understanding that the general manager, Mr. Paris, did not receive the complaint before the termination call was, for me, the deciding factor in that this could not be a retaliatory act.
So you said he didn't receive, I'm sorry, he did not receive?
Zoo, do you happen to have the date of the actual termination phone call handy?
Me? Oh, I'm sorry.
If I'm not mistaken, I think the termination was on June 14th, if I'm not mistaken.
Yeah, like I said, I wasn't prepared, but from my understanding, if I can remember, I think I remember calling somebody about it on the 18th, on June 18th. If I can go, one second, if I can go through my emails. I just don't feel like the only time I had to talk, I think it was that minute there was like an extension or something, but I'm hearing that you guys, I don't know if you guys reached out to him, but somehow you guys found out more evidence from his side, but nothing was said to me about anything, so I was just kind of left over here in the blind or something about what was going on with you guys and them.
What information?
June 17th. So he did have
He had it.
before.
Yeah, he had it.
Oh, I thought it was on June.
Yeah, so it was a lot of misunderstanding because I didn't get to tell my side of the story. It was a lot of it was another guy representing them the last time, and he was speaking, but I felt like that minute was just not enough, like, of what I had to explain about what went down. I felt like it was clear-cut retaliation about how it went down, when it happened, how the phone call between the two managers happened, and then how he just came at me about it. And about an hour phone call, we had a 50-minute phone call, like, that no one knows about because I guess it can't be spoken of or something about. Basically him, I that story at all.
Hey, Mr. Rhodes, could you mute for 1 second and let us speak, please?
Yes, yes, sir.
Point
Thank
of
you.
information. I just have a question.
Yeah.
Does the Office of like Equity and do you guys provide this evidence to both the complainant and the respondent? Because
Yes, we provide the final investigative reports to both parties.
okay, and they were provided them before this meeting, correct?
Yeah.
Okay, I just wanted to make sure that was clear for the record.
But also, when they went back, we had no questions for Mr. Rhodes. We only had questions for the Hilton side of things. So if he was sitting in limbo for a moment, it was because we were asking him to follow up with the Hilton side of things, not with him.
And just for correction, I think both sides got the same amount of minutes to speak at the first.
Yeah, they did.
It was 4 minutes.
Correct.
Yeah. There was a minute extension.
Yes.
Yes.
There
And
was
the
more time.
information about that phone call, I think, is in the report, if I recall.
The original.
Yeah.
Yeah,
Mhm.
the original report.
Well, I will admit, I was a little confused based on what was in the supplement because it didn't include the termination date anymore.
Right.
I thought that June 11th was the termination date, and then they received the forwarded email June 14th. But if they received the forwarded email on June 14th and the termination happened on June 17th, that's not as clear cut as I thought it was from this.
Can you provide the 4 elements necessary for retaliation, to fulfill a retaliation case?
Yes.
Thank you.
So the first element is the complaint engaged in a protected activity. The second element, an adverse employment action occurred. The third element is there's a causal connection between the activity and the adverse action.
Which the protected activity is them using the facilities to be able, the hotel facilities.
Well, the protected activity
It's
would
filing
be,
the complaint.
yeah.
Oh, it's filing the complaint.
Filing the complaint.
Understood. And then it's to say that there was an adverse action because of that.
Yeah,
And then what was and just the final element is that there was a causal relationship.
yeah.
Between them.
Yeah,
Yeah.
and he's
So-
saying that there is one, that he submitted a complaint and then was terminated. And they're saying it's not because of the complaint, it's because of,
The behavior
The behavior.
was, they told during the conversation.
Yeah, that's why we provided the
Right.
code of conduct, the Hilton Code of Conduct. The respondent is alleging that he violated the Hilton Code of Conduct when he was insubordinate and he rebooked the stay at the Hampton Inn after it was discussed between him and Mr. Parrish that it wasn't in his best interest to go back, as well as the language and the tone of voice that was utilized by Mr. Rhodes when he was speaking to his manager, Mr. Parrish. So that's the reasonings that they provided for why he was terminated, and not because he reported, he made a complaint of discrimination about his stay at Hampton Inn.
do we know if Hilton keeps incident reports? You know, if they've got really belligerent or destructive, whatever the word would be, guests, clients, do they keep incident reports? I do think we talked about this last time.
Well, the report was made at Hampton Inn, and the manager from Hilton received a complaint from Hampton Inn from the manager at Hampton Inn. He received that complaint on the 11th of June.
Received a complaint.
He received
From
a
Mr.
copy
Mr.
of
Rhodes's
Mr. Rhodes's complaint on the 11th of June.
But does the
He was terminated on the 18th of June.
But does the Hampton Inn, right, like if you have a really nasty client, do they not write up some sort of incident report documenting, you know, this is why this person isn't allowed to rebook with us? And then do they document, take pictures, proof of why this person isn't allowed to come back to that hotel?
I don't know if Hampton Inn does that.
So do we know
So-
whether anything about the actual complaint, I guess, and how, and what the process is of the complaint? Who does that complaint? Mr. Rhodes' original complaint?
Mr.
about
Rhodes'
his
original
treatment?
complaint was handled by Hampton Inn.
His hands up.
His
Just give us one
original,
more second,
We're
Mr.
gonna
Rhodes.
continue.
his original complaint was handled by Hampton Inn. The protected activity is the fact that he made a complaint.
Right.
We don't have to, kind of dive into the veracity of the
Of the
complaint,
complaint.
whether
I
it was
just
true
wondered
or not.
who's handling it.
Yeah.
Yeah, I guess it was.
So that just the fact that he made a complaint establishes that he participated in some kind of protected activity.
Just a point of clarification, I don't mean to interrupt, but are you talking about the original complaint that he made to OEI? Or are you talking about the complaint that
No.
he made to Hampton Inn?
The complaint he made to Hampton Inn.
Are we looking for more evidence? Or do we feel, are we at peace with this decision?
I might be willing to look, I think I want more evidence now.
Okay, I have a motion. I move to reconsider, the motion that was put on the table to, approve the determination of the Equal Opportunity Director in EO-E-2022-32. That's the motion.
Is there a second to that?
I'll second that.
Okay. All opposed? All in favor?
Aye.
Okay, so I think we want this back on the table.
Um,
But what is it that we would be looking for?
The actual complaint,
Can I borrow that pen?
the written from the company.
Well,
So
like
what
I indicated,
difference
I don't
would that
think
make?
that the actual complaint makes a difference because it establishes that he participated in a protected activity. I don't think anyone is disputing that he participated in this protected activity. The element that I think is potentially under contention is whether there was a causal connection between him participating in the protected activity and him being terminated.
Right, and so I guess what I'm thinking is what kind of evidence is we actually going to show that what happened is causal as opposed to there was a phone call where they got, clearly what initiated the exchange was the complaint.
yeah.
That's what initiated the
And
interaction.
can I say
between the
something
two
before you all put something? So once the respondent provides a non-discriminatory reason, and Mrs. Martin kind of touched on this the last time, once the respondent provides a non-discriminatory reason for the adverse action, it's on the complainant to disprove the respondent's legitimate non-discriminatory reason. Mr. Rose was never provided our office any evidence to dispute the respondent's non-discriminatory reason that his actions, that he was terminated because of his actions of violating the code of conduct and because of his I guess the conversation that happened between him and his general manager. So the onus is on the complainant to provide us with that additional evidence, and he never did to dispute their reason. So it's not on, you know, the Office of Equity and Inclusion to provide reasons to dispute that. It's on the complainant.
Then could I guess my only thing is I guess maybe, because the time from what I saw, there was still time left for the complainant to provide, you know, debate on the floor. I mean, could we just give
Well, the investigation is complete. He would have had to provide that information during the investigation.
So, okay, he can't provide it here. Okay.
I'm not trying to interrupt also.
Mr. Rhodes, could we finish our discussion, please?
And that goes to what I was saying, which is they've said that it's because of his behavior during that phone call essentially, and because he went back. And what is it that we would want that would, what could he provide to say it wasn't that phone call?
Right.
Which goes back to what you were saying, which is, they've given that as essentially the reason.
Unfortunately, exactly.
Right.
Yeah, which I mean, well,
That when they were having
fortunately,
that conversation, right.
So, sorry.
No, go ahead.
I don't know how y'all feel about it. I would like to hear more from maybe Clayton Stark about what exactly he heard. I think so far we just sort of got, well, things that sort of agreed with Mr. Paris's point of it, I think it would be illuminating to sort of just hear the rest of what Clayton Stark has to say about that interaction and the two specific phone calls that he was party to. If he was party to the "you shouldn't go back there" conversation and the termination phone call. And then this is not the time to hear this, but if it's possible, if Mr. Rhodes has, any witness on his side for the phone call, because right now we just have a one-sided witness. And so I don't know if Mr. Rhodes has someone who was in the room with him or in the car with him or whatever when the phone call happened.
Well, during our investigation, we asked both parties to provide us with witnesses, and none was provided to substantiate any. And I don't even know if he's disputing that the conversation happened, but he didn't provide us with any witnesses to this conversation.
Well, if it's too late to go back and ask for that, that's fine. But I just think that so far I've gotten a fuzzy idea of what Clayton Stark heard and didn't hear, and he's admitted that he didn't hear the other side of the conversation. So we're being told that it was he was behaving belligerently during the phone call, and Clayton Stark is the witness, but Clayton Stark could only hear Mr. Paris's side of things. So how could he hear that Mr. Rhodes was being belligerent on the phone?
Well, that's one of two reasons why he was terminated. The other reason why he was terminated because he attempted to go back to the Hampton Inn.
Which we determined that we didn't like.
I think even last time we thought that was sort of iffy because it's not written anywhere, and just saying I don't think it's a good idea that you go back, that doesn't bar him from trying to go back. I personally don't see that as a belligerent behavior. So that is already shaky ground for me.
Well, I think the belligerent behavior is the conversation. That was kind of how the conversation went. I think the insubordination is the fact that he went back and rebooked after they discussed it wasn't in his best interest to do so. So it was insubordination and I guess the belligerent, conduct of words that occurred during the call. So those are the two separate reasons they gave for the termination.
And was there any, just to definitively make sure, there was no interview of the third witness that we're talking about, which is Mr. Stark?
Yes, he was interviewed.
He was interviewed. Did he provide any sort of perspective at all on what the conversation was about, or was it just very He
acknowledged that the conversation was about them discussing Mr. Rose not going back, but he also acknowledged that he couldn't make out the actual words that Mr. Rose was saying to Mr. Paris during the call. He indicated that it was loud enough where he can hear the language was escalated, but he couldn't make out the actual words that were being spoken.
I think that as much as I would want to get more evidence on this, and I really do respect us trying to make sure that we're getting all the perspectives on this, I think that the evidence unfortunately is balanced against the complainant, just because the complainant hasn't disproved this this conversation that occurred, and I think even if we looked at the fuzzy aspect of the previous point, I just think that because there isn't anything that's been concretely leveraged to disprove this, I don't know if we can put this back up for more evidence. If you guys disagree, that's fine, but I just don't want to again be seeking out evidence that may not necessarily exist or find witnesses that may not necessarily exist, especially if again this was offered to ask for witnesses, ask for that kind of evidence, and then that wasn't provided by the complainant. I think that is just, that's just how these kind of cases, these reasonable cause cases work. It's unfortunate, and for at least the complainant, but that's just kind of where I stand right now.
So is there a motion then?
I think is there still a motion on the one to?
Well, we've officially reconsidered, so now we are back in consideration of the motion. So I guess we can. Now we just take it to a vote.
You have to give me a motion first.
Well, I guess I move to approve the Equal Opportunity Director's determination of complaint of discrimination EO-E-2022-32.
Do I have a second?
Is there a discussion after the second? I forget what the rules are. So second
Probably.
and then a discussion and then a
Yeah,
second?
I can withdraw the motion if we
Everybody
need
got
to
it?
further have
Rules of
discussion.
order?
I know we,
Yeah,
the Robert's rules is a little.
Yeah. Robert Rules of
Yeah, I
Order.
would
I
probably-
was just gonna say, I think it's one of those that, I think I support what you were saying, Jonathan, which is just, it's one of those really iffy and you can't, unless some proof was actually given, it's kind of, they have given a reasonable response to why it's not connected to what it was. And, you know, it's not beyond a reasonable doubt, it's reasonableness. And yes, so I would second that motion.
All in favor?
Aye.
All opposed, nay, and the motion passes.
All right.
He already had his 3 minutes. The board has determined that there is no reasonable cause to believe that a discriminatory practice has occurred, and I shall dismiss the, no, that's not me.
Yeah.
That's me. The board has noted that there is no reasonable cause to believe that a discriminatory practice has occurred.
Okay. The board has determined that there is no reasonable cause to believe that a discriminatory practice has occurred, and I shall dismiss the complaint. This concludes today's business as it relates to complaint of discrimination EO-E-2022-32. And we're at E, business discussion. We don't have any new business to discuss at this time. So we can do F, any public comment? No public comment. We can do G, member comment, any member comment?
So I guess my only thing is just for the elections process, can you, I guess it's more so a question than anything, but just in the future, please just, if you can keep it in email, that'd be great. But how will this process work? Like, how are we going to appoint these individuals? Like, how are we going to, what's the process there? Nominating committee, I just want to know the specifics within our bylaws at least.
So it will be by the 3/5 majority vote of the board members as far as electing
Okay.
the role for the chair and the vice chair.
Okay, understood.
And I would definitely have that information and I can get it to you also. I will know the official time frame that we need to do it by, and hopefully we can do it by at the next meeting in July.
Perfect, awesome.
So the next meeting will be July 19th, 2023. If there is no more member comment, that would adjourn the meeting.
Don't hit the motion to adjourn.
Yes.
Yeah, sorry.
I move to adjourn this meeting.
Do I have a second?
Second.
All in favor?
Aye.
All opposed? Motion passes.